Dipankar, we're audible, na? Audible, na? Hello, Dipankar.
Yes, madam, you are audible.
Okay.
Dipankar sir?
Yes, sir. You are audible. Yes, you are audible. I think Dr. Rosie Kolita has joined.
Rosie ma'am has joined.
Rosie ma'am, audible?
Hello, good morning, everybody. Good morning, sirs, madams.
Good morning, ma'am.
Good morning, ma'am.
Good morning.
Morning.
Good morning, ma'am.
Good morning. So my session starts in the next 5 minutes, right?
Yes, ma'am. We have
Yes.
little bit formality. We will introduce formally you to the audience.
Yeah.
It sounds clear, no, ma'am?
Yes, absolutely.
Okay, ma'am.
কাপোৰীয়া দি থৈছো পানীখিনি গৰম হ'ল
Pralika sir, I think we can start now. It's already 2:30.
Good afternoon to all. Myself, Pankaj Nach, Assistant Professor, Naga Law College. It gives me immense pleasure to extend a warm and heartfelt welcome to all the dignitaries, respected resource persons, and enthusiastic participants in this capacity building program on artificial intelligence related cybercrime in India and its preventive measures organized by Naga Law College and Dr. RKB Law College, Dibrugarh. We are living in an era where artificial intelligence is transforming the way we work, think, learn, and solve problems from governance, business, education to healthcare and industry. AI is reshaping our future at an unprecedented pace. Therefore, building our capacity to understand and responsibly use artificial intelligence is not just beneficial, but also very essential. This program has been thoughtfully designed to enhance our knowledge, develop practical skill, and create a platform for meaningful discussion on the opportunities and challenges that AI presents in our day-to-day life. I am confident that the session will equip all of us with valuable insights and tools that we can apply in our respective field. I encourage you all actively engage, ask questions, and make the most of this learning opportunity. May this program inspire new ideas, collaboration, and a forward-looking mindset. I'd like to introduce the resource person of the technical session today, Dr. Rosie Kolita, Senior Superintendent of Police, Chief Minister's Special Vigilance in Assam. Dr. Madam was a topper of the entire APSC batch 2004, but opted for police service. Dr. Rosie Kolita, Madam is the first and only lady police officer of Assam to receive the Police Medal for Gallantry from the President of India in 2017 for a successful counterinsurgency operation leading to recovery of a kidnapped victim and neutralization of 4 alpha cadres. Madam was the recipient of Union Home Minister's Medal for Excellence in Investigation in 2020 for the investigative acumen in a case where the prime accused was given death penalty and the co-accused were given the life imprisonment. Madam is the recipient of President of India's Police Medal for Meritorious Service in the year 2023. Dr. Rosie Kolita Madam is the recipient of Chief Minister's Medal for Outstanding Services to the State in 2013. Madam was the recipient of Antarik Suraksha Seva Padak and Antarik Suraksha Padak from Union Home Minister. It is my privilege to also say that Madam was the recipient of Gold and Silver Medal from DGP of Assam. Madam was the first woman black belt in Karate from Assam in the year 1991. Presently, third dan in black belt. I proudly say that Madam is the only lady police officer from Assam to have undergone 1 month training in post-blast investigation conducted by FBI, United States in December 2016. These are some of the glimpses of an outstanding illustrious career. Over to you, Madam.
Thank you so much, sir. Good morning, sirs, madams, and my dear students who are participating in this online capacity building program. And the topic given to me today is about AI-related cybercrimes in India and its preventive measures. When I joined policing 2 decades ago, it's 23 years now running since I joined police service. And during those days, we used to run after the criminals. Today, we run, they don't run, they just log in. They just log in. And earlier, we investigated footprints, weapons, and then eyewitnesses. Now we have to investigate IP addresses, not their addresses. Digital footprints, and most interestingly, is the artificial intelligence. What is artificial intelligence? I would, after a few minutes, I'll be showing you a PPT that I have prepared for the perusal of all the students here, which will be easier for you all to understand actually. Before I proceed, let me assure you that this person, that is me, I'm a real person. I'm not deep fake. Okay. I'm a real person. You can talk to me. You can ask me questions. I'm not deep fake. But we will also discuss about deep fake further in my speech. And awareness is very, very important. As we delve deeper, as we talk about artificial intelligence, we should also realize that they are the people, actually. Artificial intelligence, there is a man behind the artificial intelligence, of course, but it is getting upgraded, and therefore the crime is getting upgraded. Therefore, we also have to upgrade ourselves even faster. তেওঁলোকতকে আমি আগত যাব লাগিব, তেতিয়াহে পাৰিম, otherwise নোৱাৰিম. It's impossible. And what is artificial intelligence? It's like algorithm. ভাত বনোৱা যেনেকে আমি চাউল খিনি পাতিলো, তাৰপিছত পানী দিলো, তাৰপিছত বিচলটো প্ৰেছাৰ কুকাৰ ঢাকনি মাৰিলো. It's a process. তেনেকে বনাই বনাই পেলাই এটা লাষ্টত ভাত খিনি হৈ যায়. That is algorithm, and by that the artificial intelligence is developed. But public awareness is very, very important, because as you all know, I being in the police service since the last 23 years, I have understood we need force multipliers. Ami okole eku noaru. There has to be awareness in the public. And who are the force multipliers? The first line of defense is the alert citizen. মই আজি আপোনালোকক কলো, আপোনালোকে গৈ দুজনক আৰু কলে, সেই দুজনে গৈ আকৌ 10 জনক কলে. This is how we have to geometric progressionত বাঢ়িব লাগিব. আৰু মই নকওঁ যে আপোনালোকে social media আপোনালোকে নাথাকিব, সময় নষ্ট নকৰিব. সময় নষ্ট ask you যে আপোনালোকে তাৰ পৰা দূৰত থাকক. If I tell you that, I am judging you, because this is the time when you need to remain connected with the outside world via social media or whatever means you have. Jodi apnalokor social media nai, tetia hole then you will be having an irrelevant life. Moi bhabu de. Aru there are of course ways and means how to protect yourself. Enukwa nohoy je social media thakile je apnaloke ebur face koribo. Social media was not meant to destroy your identity or to destroy take away your money. Paisa nibole ba identity theft hobole bonwa nasile. Bhal eta uddesho karone banaisile, and we have to take the advantage. We have to learn from them. Aru we shouldn't become servant to artificial intelligence, because we created it. আমি এটা servant হব নোৱাৰো. We have to make use of best use of the artificial intelligence. এতিয়া চাব কিমান ধৰণৰ artificial intelligence জৰিয়তে কিমান ধৰণৰ আপোনালোকে এপ ওলাইছে, যেনেকে ChatGPT, Grok, Perplexity. তো আপোনালোকে যিমান চাব গম পাই যাব যে তেওঁলোকে আপোনালোকৰ এটা কিবা এটা খুজিলে, যেনিবা আপুনি এটা ফিড এটা দিলে যে মোক এইটো আনসাৰ লাগে, and it will read your mind. They will understand আপুনি কি বিচাৰিছে. বাৰে বাৰে আপুনি এটা বস্তু খুজি আছে, এইটো দিছে, এইটো দিছে, এইটো দিছে, তো it will understand what you want to do, what you want him to do it. তাৰপিছতে তেওঁলোকে they will start massaging your ego. Don't trust them. আপুনি যোনটো ভাল পায় হিতুহে উত্তৰ দিব. তাৰমানে মই এইটো বুজাইছো যে কিছুমান বহুত ভুল তথ্য দিয়ে. আমাৰ সময়ত আমি কিতাপে জানিছিলো, আমি এইবোৰ নাজানিছিলো. ক'তনো ইন্টাৰনেট আছিলে? আজিকালি ইন্টাৰনেট হৈছে বাৰু, ঠিক আছে. ইন্টাৰনেটত আপোনালোকে ভাবে জানো যে সব কথাই শুদ্ধ? বহুতখিনি ভুল ইনফৰমেশ্যনো দিয়ে. It has been made that way to massage your ego. তো আমি এতিয়া কি কৰিম? Let me move forward. মই এটা প্ৰেজেন্টেশন বনাই থৈছিলো, দিয়াচোন. মানে মই বেগ হেৰিতে বনাই থৈ দিছো।
Madam, sorry to interrupt you. Madam, there is a request from all the audience as they are from different parts of India. So
Yes,
it will be good if you explain in English because
English,
they don't
okay.
understand Assamese.
Understood. Kuntu,
Okay, thank you, madam.
thank you. Is my presentation visible? Am I audible?
Yes, ma'am. You're audible.
And the presentation is visible?
Yes, ma'am.
Okay.
Yes, ma'am. Now it's clear.
Okay. Then let me start with the presentation. Actually, I prepared very hurriedly. And I'm not an expert, but whatever experience I have gained during my last 23 years stint in the police service, I'll give certain brief incidents and experiences that I had, faced during my career. Most of the participants in this capacity building program are probably students, right?
We are all teacher actually from different.
Madam, there is a mixed representation from mostly assistant professors from different colleges, then students, research scholars, managers, and other legal professionals.
Okay, understood. Okay. Then it's okay. Whatever is there, it's for us, for the law enforcement agencies, as well as for the general public, as well as for the teachers, and as even for the students. So whatever I'll be speaking here now will be really very, very important, and it will be helpful in your day-to-day life actually. And starting with the transformative technology, I would like to show you about what the algorithm actually is. See, this is a recipe. And then this is finally the artificial intelligence. By the artificial intelligence, it has been created. An application has been created. And along with it, there will be growing vulnerabilities. So where there is good, the evil always exists. So it says. But we have to understand the implications of those evil consequences, and we have to safeguard ourselves against such potential artificial intelligence related cybercrimes. And these are the business models. You know what happened? I stay in a joint family home nearby to Beltala. And every Sundays, myself and my sister-in-law, we go for vegetable shopping nearby in Beltola market. And while going, we booked a rickshaw for 50 rupees. We went. And then while coming back, I paid 50 rupees because I had that change. While coming back, he said, Baido, I will need 80 rupees. I said, why? While coming, I paid you 50 rupees. Now, why it is 80 rupees? He said, no, you have got 2 bags full of vegetables. That is also, there is weight there. So I will need some more. And then I said, I've got only 50 rupees. He said, go to the back of my rickshaw. You will find the QR code. See, that happened probably 3 years back. The rickshaw puller, he showed me his QR code and I paid him 30 rupees there and 50 rupees cash. So India is growing actually. But there, along with that, certain artificial intelligence related cybercrimes also have started. So we should understand what these are actually and how to safeguard ourselves. Not only ourselves, our children, the society, how it is affecting the economy of the state or economy of the nation. We have to understand that, and so that we can protect ourselves. These fake contents, I'll show you one video in my later slide, how it is creating a havoc in Hollywood. Because artificial intelligence is it seems to be so real. You won't be able to differentiate between what real is and what is not. And these cyber criminals use artificial intelligence to automate offenses. And personal data is stolen for malicious use, as we all know, deepfake scams, identity theft. When I was additional SP, I remember in the year 2019, I was additional SP headquarter in Nagaon district. And then what happened? A person committed suicide. He was a retired teacher. When I started investigating, I found it very, very sad, and it pained me so much, because whatever amount he received after his retirement, all the pensionary benefits, retirement benefits, it was there in his account. And there was an identity theft, and somebody stole the whole amount which he had kept it there in his account, which was saved for his daughter's marriage, then renovation of his house and everything. And it was gone within 1 second. And we investigated, of course. Even if we get back the whole amount, return, but how will we return back? How will we bring back the man who died already? So it's very, very sad and painful when we think about that. And that's why we need to understand the implications, and we need to be very, very careful. Okay, now regarding deepfake technology that I already spoke about, which has created panic in Hollywood, I'll show you one small video. Okay, so if it's just a loop, how we are still here? It's an application named CDANCE, SEEDANCE 2.0. It's a new artificial intelligence video generator. So the Hollywood is actually panicking, because they have understood that now everything is possible. Low cost generation, within 15 second cinematic clip can, you just type whatever you want. You just send a few prompts and it will make a video. And it is low cost generation video featuring everything, whatever you wanted. So it's so much realistic, these deep fake videos, deep fake technology, that it's really so much convincing that you won't be able to identify which and distinguish between the real and the fabricated content. Now, as we all know, that the India's rapidly growing digital economy has presented new opportunities. But along with that, we need to be very, very much aware about the cybercrime. Cyber awareness is very much important. As I already said, that the first line of defense is an alert citizen. I can't do everything alone. And we all know that the ratio of one police personnel to public there's a vast, huge gap. So I cannot do everything alone. And we have understood that artificial intelligence is a powerful tool. And if it is in the right hand, in the hands of the law enforcement agencies, then it strengthens the law enforcement. But if it is in the wrong hands, then it multiplies criminal capability. That we should understand. Now the evolving frauds like the Indian payment landscape, fake customer care, fake job portals, fake used product marketplace. Now I'll tell you something. Once when I was additional DCP crime in the police commissionerate here in Guwahati, what happened? A lady came and reported a fraud that had happened to her. She was a wife of a very high army official, and she said she has been duped of 70 lakh rupees. When we investigated further, we came to know that she prepared a fake profile in her Facebook account. And she said, I had been using VPN. Probably VPN is understood. VPN is something which we can buy actually. By buying a VPN, okay, about that I'll talk to you about a little bit later. But let me finish this story first. And she said the person who said that he wants to be her friend belongs to US. Some David or something, she said, and she gave the URL also along with the profile photograph. He said he sent her some gifts, and then finally she has to collect it from the customs in Delhi, because the custom clearance, they asked her lots of money for custom clearances, because there were Apple iPhones, iPads, Jimmy Choo sandals, Jimmy Choo handbags, then Calvin Klein or whatever, the huge big brand names of certain merchandises were there inside the box, and therefore she had to take the clearance from the customs. So she was duped. But she told me that she used VPN. Despite that, she was duped. Now, VPN is something which can hide your identity in the internet. You can buy VPN for 500, 800 rupees. While I was investigating a certain case last year about a Pakistan, I used that so that my identity should be masked, because I'm investigating officer of the case. So I have to mask my identity. And she also did the same, but even then she was duped. How come? Now I'll tell you something. Now, if a person uses VPN, but earlier she was using social media for 2, 3, 4 years, her identity has already been there in the internet. And once it is in the internet, it is there forever. Even if you take it down, it will be there forever, because You don't know how many times it has been downloaded, it has been shared. You never know. So that happened to her. And now there is another thing, because I am here in the Chief Minister's Special Vigilance Cell. We investigate cases specifically against the public servants who are involved in corruption-related cases. It might be a misappropriation case or a disproportionate assets case. Such type of cases we investigate. Here, being here for the last 6 years, I have been investigating and I have found so much of evolution of money laundering in this digital age. You know, there are it's not like I have taken out the money from the government funds and I have kept it in my bank account. It's not like that. Because your bank account, if I have done something wrong and I have kept that proceeds of crime in my bank account, then I'll be identified. So what they use certain layers, that is called layering. The cash money that has been withdrawn, it will be given to some person. The companion, the compatriot of this accused person, this criminal, and he will keep it, or he might use it for his business purposes, and then he will transfer the same amount to an account of this criminal's family members. So that is layering. It's very, crude way or raw way of making you understand. But as far as layering is concerned, it is that way. It is done that way. And then I had investigated another case. This is slide number 10. Okay. This slide, I'll tell you something. I had investigated one case last year, in which I was the investigating officer of CID police station case, and I was investigating the Zubin Garg Dash case. And there also we found the same pattern of crime. The prime accused person, he used money laundering process to, mask the amount of money that was siphoned off from the victim. And that way we could identify, there was forensic accounting, forensic auditing of his accounts, and then we could find crores of rupees were siphoned off from the victim. So it's a very sad story. And I won't discuss much because it is still under trial in the Honorable Court of Law. So after the trial is over, I assure you we will discuss again about this case. And it's a very, very interesting case actually, and very sad also. Sorry state of affair, because certain people are making this process their way of life. Okay, and then the evolution of money laundering in digital age, I have already told you about the bank accounts and digital wallets to transfer illicit funds. Okay, another case which I investigated way back in the year 2023 and again in 2020, two cases. There were two cases which I registered in Vigilance Police Station here in the Chief Minister's Special Vigilance Cell. We have got one Vigilance Police Station. And as I told you earlier, we investigate cases against the public servants and about the public money that might be siphoned off by somebody. So what happened in 2020, some criminals from outside the state, they forced the signature of the Honorable Chief Minister of Assam. 2020, it was in the year 2020. And they withdrew, not much, but they withdrew 7.2 lakhs rupees, and small amount were withdrawn from the Chief Minister's Relief Fund. So you see, the Chief Minister's Relief Fund is an account, that account which holds a huge amount of money, the corpus which requires to be spent for the public, whoever requires it. And then when small amount of money gets expended, then the bank account, the SBI authorities, they also overlooked that. But finally, when we zeroed in after investigating, we went to one district that is called Basti district in Uttar Pradesh. And within one night, we arrested 7 persons with fake profiles and identity theft, showing themselves as Assamese people and siphoned off money in those accounts amounting to small amounts so that it doesn't get identified quickly. And we brought those people here to Assam, and presently the case is under trial. That much I can say. So see, identity theft, and they went to that extent, like forging the signature of the Honorable Chief Minister of one state. And further, during investigation, I found that they have been forging not only the signature of the Honorable Chief Minister of Assam, they have been doing that in other states also, like the Sports Fund of Tripura, that also happened there, then in Hyderabad, even in Rajasthan. And all these states, they came and, they had shown arrest these accused persons. Because these were the people, they were running a racket actually. And these were the only people who were doing that. After that, after the arrest of these people, it stopped. And now more vigilance has been, given by the State Bank of India authorities, as well as certain people have been engaged to keep a track of the funds that has been expended. Now, another dangerous trend, I would call it a dangerous trend, because the cryptocurrency, as far as we are concerned, we Assamese people are concerned, we are, very simple living. High thinking is also there, of course, but basically we will prefer spending money by Google Pay, Phone Pay, rather than, spending in cash. And therefore, this new frontier for money laundering, this cryptocurrency, has started evolving. Bitcoins, there are so many, NFTs, non-fungible tokens, it is called non-fungible tokens, like Bitcoin, Ethereum, Cardano, lots of cryptocurrencies, and one Bitcoin amounts to lots in lakhs actually. So there is anonymity of cryptocurrencies. Then there is cross-border transfer. Cross-border transfers, it makes, there's a lot of hassles to trace the originator. I'll talk about that also in my later slides. And for tracing these cryptocurrency transactions, we need specialized tools. Then there are these cryptocurrencies, once used, is irreversible. You cannot bring it back. Like what happens when you are being a fraud happens from your bank account? You can go to ombudsman in RBI by filing a complaint, and if it is not your fault, they will refund you. But here, in case of cryptocurrency transaction, once it is completed, it cannot be reversed. So this is a danger. And this transaction is super fast. You won't be able to, blink your eye even, and it will be gone. And gone means gone forever. And then privacy technologies also with jurisdictional issues. As I already said, there are lots of jurisdictional issues to trace the originator, because there might be involvement of multiple stakeholders involving international investigations, and in international investigations it happens, but you can, as we have already, as you all might have understood, there are lots of PILs in the Honorable Code regarding investigation of CID police station case number 18 of 2025, which I investigated on the death of late Zubin Garg. And accused persons, they said, how can a state investigating agency investigate a case when the place of occurrence is outside the country? But it is there in the BNSS. It is there in the BNSS when the offense is committed there, outside, but the person, whoever committed that crime, is an Indian. Then the long hands of law will go and catch hold of it. It is there in 208 of BNSS. So it is there, but the procedure is very, very long. I'll tell you about that also. And moreover, there is technical expertise problems, tools, requirement of tools, trainings, and blockchains. Blockchains are very, very costly things. But nowadays, of course, like I use all the police stations as well as all the officers in the Assam police, as well as the government agencies, they use NIC email. Like I use my email address is sp-cmec@assampolice.gov.in. So it is in the NIC. The server is in Delhi. There are blockchains which will block anybody who will try to hack our account. And if somebody tries to hack, then some signals will go, a signal will come to me and to the servers there in Delhi that somebody is trying to hack. So immediately change the password. That also happens. So like blockchain analysis hinders effective investigation. It's, a lot of investment has to be made there. And then legal complexity in data sharing from outside India, including use of letter rogatory, then MLAT, Mutual Legal Assistance Treaty. When I investigated the case, and we wrote to the Singapore High Commission, and we have already, India has signed the MLAT, that is Mutual Legal Assistance Treaty with Singapore. And according to that treaty, we can go there, but we cannot investigate there, in their country. They will be investigating and we'll have to, we can see, we can ask questions, but it has to be routed through the High Commission. It has to be approved. So there are lots of legal hassles. What I mean to say is that. And lots of application security, which I'll be discussing in my later slides. So there are, of course, provisions to protect ourselves, like antivirus, then security of the blockchains, web application firewall, distributed denial of service attacks, the antidotes for DDoS. So there are lots of provisions also. I won't say that we are now defenseless. It's not like that. We have got our preventive mechanism, which we have to use logically and rationally and protect ourselves. We all know now earlier it was different, but now we don't click unknown links, right? We don't share OTPs. We are trained now. Earlier it was not like we didn't know much. Before transferring our money, earlier we used to transfer the money whoever sends the QR code, but now we will send only 1 rupee first and then ask whether it has gone or not. If the 1 rupee has been transferred, then only the next phase, we will carry out the next phase with the amount that we have to transfer. Like, we have to verify through a second method of communication. Otherwise, we can also keep on, with another phone, we can talk to them and then verify, have you received the 1 rupee in your Google Pay? Then once it has been verified, then we are transferring. Like, we have to question before we do some act. Before forwarding a content, we have to question ourselves. We have to think, we have to protect the digital identity, like the way we protect our physical identity. See, the mobile phone is so much identical to ourselves. Once we lose the phone, mobile handset, we will feel like my identity is lost. Because everything, my phone book, my bank account numbers, my social media accounts, my email accounts, it's all gone. So that is also an identity proof nowadays. Like we have to protect that digital identity, like the way we protect our physical identity. And we have to report immediately about such, if some suspicious activity happens, like some scams. If it happens to me, you know what happened? As I already told you, I live in a joint family. My sister-in-law, what she did, a phone came and she picked up the phone, and the person said, you have got a parcel from Amazon. She said, how much? He said, 400 rupees. She went outside and she paid without even thinking. She thought maybe I already might have, purchased, and it was probably cash on delivery. And when she opened it, she was surprised. I didn't order for this. It was one small bottle and it was written black shampoo. And she said, what is this? I said, what black shampoo? She said, I don't know. Maybe my daughter might have ordered. She confirmed it from her daughter. She said, no, I never ordered for any black shampoo. Then I said, you throw it. Otherwise, if you are going to use it, you will become bald. Takla hui jaba, pelai dia. And she threw it. So now what happens? That's why I always insist. You pay it. It shouldn't be cash on delivery, because, when these boys come, delivery boys, they always take a photograph of the address, of your address, and they, take the photograph and they leave. And we also think that it's a normal procedure. But who knows? They might have made the Xerox copies of those orders and then pasted it on a brown paper cover and then delivered it for 400 rupees. So only 400, thankfully it was only 400 rupees. Had it been a huge amount like 1,000, 2,000, what would have happened? So we should be very, very careful. So it's better, we should be very, very protective about these matters. And we have to verify it, cross-check it first. And, technology is not the enemy. Our ignorance is what I feel. And then there is OTP theft, as I already said, the voice cloning, fake investment apps. Once the phone starts ringing, the spam phones, they will ask for, they will tell you your name. They will say, am I speaking to Dr. Rosie Kalita, then I'll say yes. Then they will start with, we have got a very good policy, insurance policy. Since you have got account in ICICI Bank, so we would like to refer this policy. Then I don't have an account in ICICI Bank. I have only one account in SBI, and that to my salary account. So we have to be very, very, smart, and we have to keep our sensors open. And rather than that, we have to ignore those calls. Because these people, these cyber criminals, they know that young people live online. I'll tell you once again that young people live online, but the older people, they are even more, excited to be online. They love reels. They love to share contents, and they love to pick up phone and talk to all those unknown people. And they would love to share their OTPs, and that's how these fake investment apps, they will lure the money, our hard-earned money. Then there is misinformation impact, I have read it somewhere, like if we upload a good video of somebody, it will not last long and it will get not more than 100 or 200 likes. But if you upload a content, a video or a photograph, denigrating some person, saying something bad about a person, then you will get, more than 10,000 likes, because people love these fake contents. People love these negative things. And even if people doesn't like, people might not like, but the algorithm likes. The brain of these applications, it likes, because they know that once it suit in a Amazon or maybe Myntra app, then every time you check in the Amazon or Myntra, the same thing will pop up. Because it has learned, the algorithm has learned that what we want to see. So such type of things we should be very, very much cautious about. And therefore, certain videos, I've heard about this movie, one song of that movie called Dhurandhar. That song was so much hit song. And, because once it was liked, then there are people, there are professionals sitting behind, the advertisements. And this digital platform, they don't need money. And it can be advertised free. So see, so it was so much hit because of the artificially generated news. The technology, the social media manipulation, we have to understand. Am I audible?
Yes, ma'am.
Yes, ma'am.
Okay. So, and what happens? This e-commerce, once you check in, like the Myntra or whatever applications are there in your mobile phone, you have seen, like, they will advertise an item for 99 rupees. And they will say it is ending within 2 minutes. And immediately you will click it. Because you don't want to lose that opportunity of buying an item for only 99 rupees. But up to the moment you check out, it will become 120 rupees. Am I right? It happens. So see, this is the e-commerce, the smart market, which has been artificially generated for the purpose of their business. So we have to be We have to be very, very careful, and we have to understand actually which one to use when. Like some people say that if you want to grab the latest news in the media or anywhere in the world, you can ask Grok, G-R-O-K. It's like ChatGPT, because the Grok extracts the information from Twitter. And if you want to, do a deep thinking, if you want to make an analysis of certain things, then you can ask ChatGPT. So we have to be very much, choosy. We cannot invest ourselves, our time in a single application. We have to understand, we have to cross-check, we have to ask everywhere and then understand which one is the best. And if we say, if we ask ChatGPT that I want to buy a t-shirt, which one will be the best? They will, simply prompt one answer, but we have to ask, like, make a smart choice. If I say that I've got allergy to nylon or terry cotton, and I don't want to wear half sleeve, I want full sleeve. It should be high neck, shouldn't be like. So we have to, if we trim down our choices, then it will start working. The application will start working, and then they will, generate from wherever those business houses are there. Then they will extract the information and give it to you. So we have to understand. We have to know which one to choose, which one to pick, and then make use of it. We have to control them. We won't allow them to control us. There are lots of PR agencies, behind their back, which will, send information to us. And as I already said, regarding the social media manipulation, there will be dopamine spikes. If we keep on scrolling down the reels or shorts for YouTube or reels for, social media, like platforms like Instagram or Facebook or whatever, and then you will get spikes. You'll be so much excited. And what I have felt, people usually nowadays used to say that 2021, how it went off, I couldn't even imagine. It was so fast. No, it wasn't fast. It is the same 24 hours that we spend every day. It is the same 365 days that we spent in the year 2024 or earlier, beyond that. Why it is like now it has become so fast? Because of the dopamine spikes that is giving us a kick. We should understand when to stop. We should know what is the screen time we have spent in checking these reels or shorts. Wastage of time, I would say. It's total wastage of time. And, the social media platforms, those business houses, they don't need any digital marketing or performance marketing. Just send a message and we will be happy checking that. And our time is gone, our energy, everything is gone. Along with that, we might lose money also. So the financial losses, individuals and businesses face significant economic impacts, as I already told you about the impact of cybercrimes in society, privacy violation, reputation damage, and then the IT Act. Probably the next session will be conducted by Honorable Judge Sir Roshan Lal, and Sir will be able to talk at length about the IT Act 2000. But here I would like to talk about the Digital Personal Data Protection Act. There is an act of 2023, which establishes guidelines for data privacy, protecting individuals' information, and mandating accountability for organizations handling personal data in India. But one thing I would like to state here, that there are no penal provisions in this act, but there are, fines mandated by this act, and the fines can go cross over to 230 crores to those guardians who are handling or mandating our personal information. So there are provisions there in this act. There are rules, of course, but the act is of 2023. The rules are of 2025. So how do we protect our data? As I already said, we shouldn't share personal information online or even offline. Somebody might ask over phone, what is your OTP or what is your password? Everything we say, don't think that I'm using phone one-to-one, so nobody is listening to me. No, everything we say, everything we are conversing over phone, it is being listened upon by somebody. I won't say it is the law enforcement agencies that is listening to your conversations. It is being listened upon by the artificial intelligence. Once what happened, a person, he kept his mobile phone near his keyboard and he was playing the keyboard. And he was preparing a tune. And that tune was hacked because of the phone that was kept nearby to the keyboard. He lodged an FIR. It was there in the internet. I have read it somewhere in the internet. It was a big news way back then in the year 2015 or 16. I remember that. So nothing is secretive now. Everything is open. So we have to be very, very much careful. We have to verify the messages and we have to keep strong passwords. Like my mother or my father passed away last year. So I'll talk about my mother now. I told her, I gave her a handset. Earlier she used to have that keypad wala mobile, but nowadays I said, so that you can, see us on WhatsApp, you take this mobile phone. It was a Samsung mobile phone. And I said, you keep a password because her grandson, he keeps on fiddling with the mobile. So I told her, okay, you use a complex password so that he cannot break. Then one day when I went to my mom, she said, he is using the phone. I said, how come I asked you to put a complex password? She said, it is 1, 2, 3, 4. So usually this is the problem with us people. We are so simple. We think that 1, 2, 3, 4 is a password which cannot be hacked. But that is the most of the time that password is being used by people, and easiest password, which can be hacked anytime or anybody. So strong cybersecurity infrastructure protects sensitive data. So there are cybersecurity preventive measures also. It's not that we are all vulnerable and we will now die, what to do. It's not like that. The good news is that we are not helpless. There are certain platforms. Just one thing is lacking is our awareness. We have to be very much aware so that we can protect ourselves. So this is another one, like as Nagaon Law College and Dibrugarh Law College has conducted these training sessions. It's cybersecurity awareness and skills boosting training, actually. And it's very, very important. Awareness is the strongest shield, and artificial intelligence is not inherently dangerous. It is a tool, of course. It is a tool. The question is who controls it? How informed we are? how much informed we are, we should know that. So there are, of course, cyber units in Assam. There are 2 cyber police stations, one in Dibrugarh, one in Guwahati, in front of CID headquarters in Ulubari, and the other one is in Dibrugarh. So, and these 2 police stations are dedicated cybercrime police stations, and it can ensure a focused approach for addressing such technological crimes. And online reporting is also there, like 1930, it was already there, it is there, and help desks are there. And 1930 is being maintained even now by CID headquarters, that is here in Ulubari. So Assam leads the nation in scientific policing. You know, I'm very happy to share that even last year, 2025 December, the Honorable Union Home Minister declared that Assam is leading in rank 1 for invoking sections of BNSS. With BNSS, I would mean that electronic evidences and submission of charge sheets in electronic form has been enhanced in Assam, much more than the other states. So in Assam, what we have is the CCTNS. Of course, it is there in other states also. NAFIS is also there, National Automated Fingerprint Identification System. In NAFIS, earlier that there were manual fingerprint system, like we used to take the imprint of the criminals and then keep it for record. But now it is automated. And it is not only the fingerprints, only the name is the fingerprint identification system, but it is there for identification of the iris. There will be iris scan, there will be biometrics and everything, the height, every minutest detail will be there in that automated system. So that such data storage will help in identifying further in the criminal activities of certain repeat offenders. And then there are 2,000 CCTV cameras in the city of Guwahati now, and which has been monitoring day in and day out whether it rains or whether it shines. So we are under direct surveillance and real-time surveillance. Then community engagement apps are there, like Sisu Mitra program is there for speedy justice delivery to children facing abuse and exploitation or other vulnerabilities online. And then there is integrated traffic management system, then cyber security and cybercrime units. There is also another cybercrime unit in the crime branch police station in Guwahati. So this is ICJS. As we all know, there will be CCTNS, there is e-forensics, and we keep on downloading the expert opinions that has been prepared in the forensic sciences laboratories across India, or if it is done here in Kahilipara or at Kamrup rural, then there are e-codes. All these are, interconnected. When I investigated the case, Zubin Garg death case, we recorded statements of the witnesses in e-Saksha. So what is e-Saksha? Let me tell you something. E-Saksha is it is an application. It is an application where we have to record the statement of the witness, which will be recorded in a real time. There will be timestamp, and then after completion of the witness statement, even the person who has been recording the statement, the photograph of that person, if I record the statement of the witness, then my photograph has also to be uploaded. The person, the witness's photograph will be there, of course. My photograph has also to be uploaded. Apart from that, there needs to be 2 witnesses also. Their photographs also are to be uploaded in that app. So, number generated, SID, that is called SID number, that number generated will be written in the statement there. And once that SID number is there, it will be sent, after it is being sent to the Honorable Court during trial, the Honorable Court can, go through the entire videograph of the statement that has been recorded by the IO during investigation of the case. So key application areas like chain of custody, which we have been doing because there are certain possibilities of losing out, or we might lose the item that has been seized. We might misplace an item that has been seized. But when this chain of custody is there, basically it was created for digital evidence. But nowadays what we do it for all the evidences, not only for the digital evidence, so that the custody of the item, whenever it changes hands, it will be written there. And finally, when the seized item, once we seize and then we send it to the Forensic Sciences Laboratory, we get the sign of the person, whoever receives the item in the Forensic Sciences Laboratory. And once he hands it over with the expert opinion, we also he will, take my signature and I will take his signature in that chain of custody format, and then I'll bring it here in the police station. And once I submit the charge sheet along with the items that has been seized, I'll submit it to the Honorable Court, and then we will take the signature of the court assistant that it has been deposited. So my work ends. So this is called chain of custody. Although it is, it doesn't have any, digital footprint, but it is very, very important. These are key application areas which nowadays, I might not take the signature, but there might be barcodes to identify where the item is presently located. So these are certain areas, key application areas, after the case is being investigated. There are much more, but few challenges are also there. I won't say that we are perfect. We don't have any constraints, but there are certain constraints, specifically the public trust. The public trust we have to gain, and it's a reciprocal process. It's not that I'll keep on talking and you have to listen because I'm the police officer and you are the victim. It's not like that. You have to share whatever is there in your mind so that I can work upon that. So it's a reciprocal process, and that we have to overcome. And there are, of course, technical difficulties, there are public grievances, and we have to, redress those grievances immediately. Once it takes time, the public trust is lost. So time is a factor, of course. And then to keep the trust of the people, we nowadays, what we do, we wear body-worn cameras. Whenever we go for house searches, we use cameras. And the entire proceeding is being video recorded, so that nobody can say that it has been doctored. It has been prepared. And the entire video, the whole video has to be a continuous video. It shouldn't stop, because once it stops, then it can be manipulated. It can be, edited. So it has to be a continuous process that we maintain. We always maintain. And then there is the Cyberdome in Kahilipara, Special Branch Headquarters. There are experts who can, trace and analyze. If somebody keeps on, searching the internet by the word Pakistan, cybercrime, Cyberdome will detect the IP address. Why he is typing Pakistan. So that way also it will be identified. So we have to be, without liberty, this security is also a prison. So it was a very well-known proverb, I would like to say, by Benjamin Franklin. So we have to know, we have to understand how to use artificial intelligence so that we can keep ourselves secured, so that it doesn't become a prison for us. So that is all. So I'm free for any question.
Thank you, madam. I request the participants, if you have any questions, please write in the chat box.
All the questions coming up. Thank you so much, ma'am.
I
Good afternoon, sir.
Good afternoon, ma'am.
I request Troloko Hazarika, Assistant Professor, Naga Law College, please introduce our second speaker, resource person of the session. Over to Troloko.
Good afternoon, one and all present out here. Myself, Prolukya Hazarika, Assistant Professor, Naga Law College, welcomes respected resource persons of this particular session. Already, Dr. Rosie Kalita ma'am has already presented our insightful objectives regarding this particular topic. Next, our respected resource person, Mr. Roshan Lal sir, and other institutional heads of various law colleges, respected faculty members, and all other participants on the second day of 6 days online mode of capacity building program on Fortifying Digital India, Understanding Cyber Threats and Regulatory Frameworks. And today's topic is AI-related cybercrimes in India and its preventive measures. So it's my privilege to introduce before you all Mr. Roshan Lal sir as the resource person for this session. Will grace the occasion with his kind presence and insights. He is already present here. Sir is an alumni of Campus Law Center, Delhi University during the term of 1999 and 2002. He is an Assam Judicial Officer, cadre of 2004 batch. He holds the distinction of being the first judicial officer in the state to crack the limited departmental competition examination. Sir has worked as faculty at Judicial Academy Assam during the period of 2019 to 2021. Under his initiative, all the courts in the district of Karbi Anglong were transformed into 100% e-filing courts, which is a rare feat in the state of Assam. Every court under his jurisdiction now generates and issues summons, warrants, and other processes electronically, ensuring transparency, efficiency, and speed. As the chairman of the DLSA of Karbi Anglong, Sir has shaped DLSA into a distinct movement. Sir has initiated the anti-drug awareness drive named as FOZAG and conducting a massive campaign across 25 higher secondary schools in the interior region of Karbi Anglong, interacting with over 10,000 students. Under his process, Sir has built a student volunteer network in every school linked with WhatsApp for constant engagement and support. The culmination event of FOZAG was graced by Honorable Mr. Justice Ujjal Bhia sir, Judge Supreme Court of India, adding stature to the initiative. DLSA Karbi Anglong, under his leadership, became the only legal aid institution to be acknowledged at the state level. Sri Sujit De, an employee of DLSA, was conferred the Lok Seva Puraskar, awarded by the Chief Minister of Assam. Sir has initiated medical profiling of all convicted inmates in coordination with Health City Hospital, Guwahati, and Difu Medical College, ensuring that convicts' health parameters are routinely recorded and monitored. Sir, same is, let me say about these things. because,
These are not, brother, these are not relevant today. So far as E-code is concerned, that was relevant. Otherwise,
people have to know
It's important.
No, sir, it's important, sir. It is important.
the Difu Medical College convinced to set up dedicated wards and counters for the transgender community, a first in district level medical outreach, conducted special training for doctors on snake bite management by Dr. Surajit Giri, and ensured anti-snake venom availability in all PSCs in the district. Sir has also proactively engaged with private schools to sensitize them on the government school bag policy, focusing on implementation and reducing the burden on young students. Sir is currently engaged as presiding officer, MSCP Gwalpara district. So these are some of the noteworthy notes regarding his stalwart personality in the legal field. It's my sincere apology before sir if I have made any mistake in these references and also forgot to mention anything because of my limited knowledge. I request you, sir, to go on this session. Thank you, sir.
thank you very much. It was a very long epilogue, not befitting the person before you. These things, like Roji and I, we do it in our professional capacity. So they are like the duty imposed, and the duty imposed is done in a manner which the statute, the law, and the public expect from us. So that is there. But yes, one thing that I will believe, well, I'm very happy that you pointed out was that Karbi Anglong during my tenure at the district and session judge was the first district in Assam which had 100% e-process generation and transmission. So that was something I am happy and proud about. And that is a way forward for all the courts in Assam. Good morning, everyone. I will request all of us to have the video on at least for a few minutes so that we can see each other. It is an opportunity to be here and to interact with all the law teachers across the state of Assam. As judges, we hardly get to talk to people beyond the courtrooms. And in the courtrooms also, basically, we are listeners and not speakers. So after such a wonderful presentation by my sister Roji, and whom I know from my school days, my session is bound to be boring and not interesting. However, I will try to give a competition to Roji and place some facts before the house today. My request again is that we should open the video so that we can see and interact. Seeing is very important. I'll begin with one question to all of us. The question is that when we go to a petrol pump and when we fill up the fuel in the petrol pump in our car, by a handheld device, they generate a receipt and the receipt is given to us. Similarly, when we go to a supermarket and we buy some goods and we make the payments, they generate a receipt and the receipt is given to us. Now, the first question that I would want all of us to discuss and answer is whether these types of receipts that we received by us is an electronic evidence, is an electronic record or not. Is it an electronic record or is it not an electronic record? Now, before I proceed further, I will want some of us, 70% are shown in the screen, around 70%. And I will want someone to please answer this query so that we can then have a tempo to start the discussion.
No, sir, it is not an electronic record.
Not an electronic record, yes. He's Mr. Sarkar, I think. From where are you speaking, Mr. Sarkar?
Sir, I'm speaking from Gwalpara, sir.
Yes, any other view? I will want, how many law colleges are there, Sujata? How many law colleges are there today?
Audio, I think her audio is.
Yes. Yes,
Sorry,
Sujata
sorry.
is audio.
Nagar Law College, Dr. RKB Law College, Tejpur Law College, Dispur Law College, Tejpur Law College,
This full.
Kolkata,
তারপর অফিসার আমি তাতে যেটু দিছে বিফোর সেটেলমেন্ট এটা সিওরে করব
Goalpara.
Goalpara, and Dipankar, what are other colleges, law colleges from Upper Assam?
5 is sufficient.
From Upper Assam, it's SIT Law College and CJS, Center for Juridical
Center for
Studies.
Juridical Study, SIP.
SIP.
Is it Dibrugarh or Junar? Where it is best?
Dibrugarh,
It's
Dibrugarh.
Dibrugarh, sir.
Dibrugarh.
It's
Dibrugarh. So, so many educated, defined law colleges are there. And I'm getting only one answer from Goalpara. Why? That takes us to the basics actually. So what is the electronic record? What is the digital record? Yes, it is an electronic. Linjyoti Bora is speaking. Yes, it is an electronic record. Definitely, yes, answer is this. It is an electronic record generated from a computer. So it is an electronic record. The next question is that whether it is an electronic evidence, whether it is an evidence, if it is put in a court of law, will it become an evidence?
Yes, it will be considered as an evidence in the court of law.
Yes, madam. Who is speaking? Madam Jupiter, I think. No? I'm
Yes,
getting.
sir. Just yes, sir.
Please identify yourself. Please identify yourself. Which college, from where are you speaking?
Yes, sir. I'm Dr. Jupiter Devi from Tejpur Law College. Tejpur.
Yes. Tejpur is a good place. I was born there. So it has to be the best place.
Very nice place. Thank you for your
So-
nice feedback.
Yes, it is an electronic record. It is an electronic evidence. Why, I will tell you. Now we begin the formal session. Now some people are talking, so I can talk. You see, when we talk about electronic evidence or digital evidence, we have to go back to the Evidence Act first as to what is electronic evidence and what is digital evidence. If we go to the Evidence Act, section 2 becomes very relevant. I'm sharing a screen. I'm not very good in sharing all these things. So I have a person who is working with me. He will share it with all of you, this part. So we'll share the screen and then we'll talk about it. Section 2. Maybe I don't. Second. Is it okay? Did you know? Because so I believe I'm visible and audible.
Yes, sir. It's clearly visible.
So when we go back to the words, there are two words that we must know, and it is in the reverse order. Normally, when we have begun with the word electronic evidence, I will take you back to first evidence and then to the word document. In India, it is very strange that though the Evidence Act has been remodeled at the Bharatiya Sakshi Adhinyam, and though the Law Commission has said on occasions more than one that the definition of the word evidence needs to be changed. The Parliament in its wisdom has not changed the definition of the evidence in the new Bharatiya Saksha Adhiniyam. The word permits or allows to be when you go to the court as a witness and when you depose, and then I speak what I want to speak, or when I give the evidence through video conferencing, and then I take the oath and I give the evidence through video conferencing, that is oral evidence. And the second part of the evidence which we are more concerned today is the electronic evidence. So it says documentary evidence. All documents, including electronic evidence produced for the inspection of the court, is electronic evidence. So this is the first part, evidence. So oral and documentary. Now documentary will include electronic evidence. Now we go back to the word document. What do you mean by the word documents? The word document is a very interesting definition in the Evidence Act and in the Indian Penal Code, now called by different names. It says that any matter expressed or described upon any substance by letter, figure or mark. By letters, figures or mark. On any matter which is expressed, when your son draws something, that is also a document. When I write something on a stone, when we were teenagers, we used to write something on the stone, that is also a document which is intended to be kept as a record, or which has been used as a record, which may not be intended, but which has been used as a record for that matter, is a document. And now what the Parliament has done, it has specifically said, and it includes electronic and digital records. So the word, put it in very simple words, the word document is very widely defined. Anything, kagozot kiba apni likhile, apni pathorat likhile, apni any scribble korile, apni draw korile, everything is a document. And now they have said even electronic records and digital records are evidence. So we go back to these two parts, that when we talk about documents, when we talk about evidence, when we talk about electronic evidence, we must go back to the basics, the definitions in section 2 of the Bharatiya Saksha Adhiniyam. So that is the first part. Am I a little bit clear? I hope
Yes,
I
sir.
can try again. Because in a video conferencing it is very difficult. The electronic evidence will have to have two important definitions to be known. One is the meaning of the word definition, and another is because one is the meaning of the word evidence, which means oral evidence and documentary evidence. Since the second part is documentary evidence, so I mean documentary meaning to a silos. A document of कोई the document will include electronic records and digital records. So I hope I have been a little bit more clear now. I want some positive affirmations so I can proceed to the next stage.
Yes, sir.
Yes. Now I will go to an interesting case. I will request all of you to write down this citation. This case is Arjun Pandit Rao Khotkar. Arjun versus Kailash boli kochu citation to apna log paye jabo main koi lisu. Arjun versus Kailash. It is 2020 bracket or likhibo. 7 SCC Supreme Court cases page 1. Arjun versus Kailash 2027 SCC page 1. Itu belagata important publication of published korise in the All India Reporter. In All India Reporter it is AIR 2020 SC 4908. In either of the two books you will get it, and now it is available in Google on the legal sites also. Now what is the case? This is a very in 2011, in 2014, assembly elections took place in the state of Maharashtra. Elections for MLAs took place in the state of Maharashtra. For one particular seat in the district of Nagpur, the winning candidates and the margin between the winning candidate and the losing candidate was only 296 votes. So the losing candidate filed a case under the Representation of People's Act before challenging the election. Am I clear?
Yes, sir.
Am I clear? Yes, I
Yes,
want
yes.
many years. You can proceed. So it was a case where the losing candidate for the seat of an MLA in one district in Maharashtra filed an election petition before the Bombay High Court. And he had taken 3 grounds in his plea. The margin, the winning and losing margin was only 296 votes. So he had taken 3 plea. For the purpose of our discussion today, we will concentrate only on one plea. The third plea was that the last date of nomination, filing nomination was, I'm giving a date, was suppose the last date for filing nomination was 15th of March 2014. This is not the exact date, but I'm just telling you 15th March 2014, and the last time to receive the nomination was 3 p.m. The losing candidates contended before the Bombay High Court that this person who had won the election entered the chamber of the returning officer at 3:45 p.m. So he cannot file the nomination before 3 p.m. So he contended that this person who has won the election has filed nomination after the last hour, time permitted, and he relied on the CCTV footage of the chamber of the returning officer. Let's see, the CCTV footage shows that when he entered the room, it was already 3:45 p.m. Now, in this case, after a lot of discussion, Bombay High Court agreed with the petitioner and set aside the election of the MLA. So, Arjun Panditrao Khotkar, who had won the election as an MLA, his election was declared null and void by Bombay High Court, and the losing candidate, who had lost only by 296 votes, was declared the MLA for that seat. Against this decision of the Bombay High Court, the candidate who had owned the seat, who was the sitting MLA, preferred an appeal before the Supreme Court, and that came to be registered as Arjun Panditrao Khotkar versus Kailash K. Godial, 2027 SEC, page 1. So in this case, Supreme Court has done lot of discussion on the relevancy, admissibility, and the value of electronic evidence, the weightage to be given to such evidence. Am I clear?
Yes, sir.
Yes, sir.
So you see, now before the Supreme, this is a 3-judge bench decision of the Supreme Court. 3 judges were there. Supreme Court generally sits in the bench of 2, 3, or 5. They do not sit single. So it is a 3-judge bench decision of the Supreme Court. The judges were Justice Nariman, Rohinton Nariman, Justice Ravindra Bhatt, and Justice Rama Subramaniam. These were the 3 judges in this bench. I will not come to the decision now. If I go to the decision now, everybody will lose interest. So we'll again leave it to what the Supreme Court said in the end. We'll now come back to the main act that we have, and we will discuss the act slowly and thoroughly. Give me a second. Give me 1 second. So, with these facts in our mind, let us discuss the law with regard to the topic that we have selected, the relevancy of the electronic evidence, the admissibility of the electronic evidence, and the value or weightage to be given to such electronic evidence. The 3, আমি এনেকে ভাবিব লাগিব এইখিনিতে যে 3টা চেক গেট আছে, যেনেকে আমাৰ ৰজি বাইদেউ আছে, তো আমি পুলিচৰ কথাই কওঁ. So we have 3.
Just
Yes,
Madam.
madam.
Actually, we have participants who doesn't understand Assamese.
Okay, no problem. So,
Thank you.
since Rohini madam is with us, so we'll talk about the policing language. So let us assume when we talk about electronic evidence that there are 3 checkposts one after the other. Apni first checkpost to cross koile, you can go to the next checkpost, and if you cross the second checkpost, then you can go to the third checkpost. So let us understand the language of checkpost only. So in Evidence Act, in any Evidence Act, whenever we talk about any evidence, we talk about the relevancy of the evidence, admissibility of the evidence, and the value or weightage to be given to that evidence. Or you can also say genuineness or not genuine evidence. So, checkpost, kindly, I will request all of us to write it down in our notebook so that we can have a mental frame as to what we are talking. The first checkpost is the admissibility of the evidence. Admissibility of the electronic, whether the electronic evidence is admissible. This is the first checkpost. The second checkpost is, if admissible, whether it is relevant. And third is the genuineness or not genuineness of the electronic evidence. Check gates, the 3 check gates. Am I? Yes. So for one of the participants who has asked the question, can we repeat it? Yes, we can definitely repeat it. The first check gate is the admissibility of the electronic evidence. Admissibility is the first gate. The second gate is the relevancy of the electronic evidence. And the third gate is the weightage, the weight that we will give to the evidence, whether it is genuine, not genuine, if genuine, partly genuine. So what type of weightage we are going to give to this electronic evidence? These are the 3 gates that we have to follow one after the other. Here, I will be a little bit, I have to just, because I am a judge and I have to tell the law. So I will tell a little bit about the legal provisions in the Evidence Act, which will be definitely boring, but I have to refer to that so that and when I'm talking to law, the legal teachers of law college, I'm bound to speak on those points. Section 136 of the Evidence Act, if all of us has the Evidence Act with us, may just flip it, or if the mobile is there, we can just go to 136 of the Evidence Act. And surprisingly, yes. 136 of the Evidence Act. Now, under what provision it is there in Bharatiya Saksha Adhiniyam? Under the Bharatiya Saksha Adhiniyam, it is 141 of the Bharatiya Saksha Adhiniyam. It says that when either party proposes to give evidence of any fact, the judge may ask him, the party, how this evidence is relevant to your case, and in what manner, if the fact is proved, it would be relevant. And then the court will decide, the judge will decide whether to admit this evidence or not to admit this. This is a discretion given to Indian judges, both under the Evidence Act and now under the Bharatiya Saksha Adhiniyam, under section 141 of the Evidence Act. 141 subsection 3 to the may sound, that is very important for today's discussion. It says that if the relevancy of one fact depends upon another fact being proved, the judge may in his discretion either permit the evidence of the first fact to be given before the second fact is proved, or require evidence to be given of the second fact before evidence is given of the first fact. Now, what does it say? Electronic evidence to start Korilu. We started by saying that the CCTV footage, the bills that are generated on the computers, the WhatsApp chat that we see on the mobile phone, printouts being given the code, the Facebook, sometimes obscene photos on Facebook, the printout being given to us. These are all computer generated, machine generated, and therefore electronic evidence. Now, electronic evidence, my dear brothers and sisters, are of 2 types. One is the primary electronic evidence, and the second is the secondary electronic evidence. Just give me a second. Now, the primary document and the secondary document, we need to understand this is a very important concept in Evidence Act, not only in the electronic evidence field, but in other field also. Primary evidence, primary document, secondary document. This is very important in any sessions on Evidence Act. Most of us are knowing about it because we are law teachers. Primarily, it says the original document is the primary document. So in a sale deed, if the original sale deed is produced before the court, signed by the sub-registrar, with the signature of the party, it is a primary document. If it is a will, the primary document. So the original document in common sense is called the primary document. Certified copy of the same or any other form is secondary evidence. Now in electronic evidence case also, there are primary evidence and secondary evidence. I'll give you one example. Suppose I get offending, threatening WhatsApp messages on my mobile phone. So I go to the judge and depose as a witness and present my mobile phone and show it to the judge. Sir, see, these are the messages that I am getting from Mr. X. So now since the primary evidence is produced in the court, the original has been placed before the court, it will be looked into in a different manner than if I take a photocopy, print out of the WhatsApp chat and submit it to the court. If I take a printout of the WhatsApp chat and submit it to the court, it is a secondary evidence. Am I clear? Am I clear? So if the original mobile phone, if the original laptop, if the original computer machine is presented in the court, and the relevant chat, the relevant things are shown to the court, it is a primary electronic evidence. On the other hand, if the CCTV footage is taken on a pen drive and submitted in the court, or if a printout of the Facebook nude photos are presented in the court, or the WhatsApp chats are printout is taken and presented in the court, or CDR is generated and the CDR things are submitted in the court through printout, these are all secondary electronic evidence. I believe now I am a little bit clear. This part is very relevant as we will come down a little later. Madam and sirs are writing yes, but they are not speaking. Let us all speak yes, no.
Yes,
they are talking to humans, not to robots.
If we keep the microphone on, then it will echo, sir. That's why.
No problem. You keep on. With me, there is no problem with echoing, etc. Because I take this session only because it is an opportunity to talk to people who are in the legal field. Okay. So it's very simple. Now question will come up in our mind. Okay, what will happen if the original phone WhatsApp chat is shown, but it is not genuine? You know, it can be manipulated nowadays. So many softwares are there, as Madam Roji was referring to. We'll come to that part a little later on. We'll come to this part. So suppose the WhatsApp chat is shown, or suppose my Facebook page is shown where threatening messages are being posted, or something which is obscene has been seized from my laptop and presented to the court by the police in a criminal case. So this is a primary evidence. Police may take a plea that, sir, it is Roshan Lal's laptop. We do not need anything more. This is a primary evidence. Primary evidence, original has been produced. So please rely upon it. I will not answer this question now. I will answer this question a little later. For the purpose of our understanding now, I am just saying this much. Yes, madam, sir. Yes.
May I speak, sir?
Yes, please.
In the last case that I investigated, that's why what I did, I took the secondary evidences first because they all belong to a different country. Because the case was running concurrently in that country as well as here. So earlier we took the secondary evidences, and then later on, after completion of their inquiry, we seized their mobile handsets. And then finally, we sent all the primary as well as the secondary evidences to the Central Forensic Sciences Laboratory in New Delhi. And we sought whether these videos were doctored, edited, and then we also saw the transcript. So 4 evidences we have already done and it has been completed. So hopefully the Honorable Court will see to that also, that it gets admitted and it is of course relevant to the entire investigation.
That is why you have made me drink water when you are starting the question. There's a very correct procedure. There's a very, very correct procedure. Now, I will, as Madam was saying, secondary evidence was initially seized and brought on record. Then when the primary evidence was made available by the police of another jurisdiction, that was seized. Both the evidence were brought to the notice of the court, supported by experts, examination of the primary evidence, an expert report accompanying the primary and the secondary evidence to the court. That is a very correct way of doing investigations. So we are now again into this small thing, that primary evidence and secondary evidence. Primary evidence means the primary document means the original document. In case of electronic evidence, primary document means the mobile itself, the laptop itself. But if we take a document from this computer, put it in a pen drive and submit it in the court, it becomes a secondary evidence. It is called output. The moment it is an output in any form, printout or through a video. Suppose a CCTV footage shows that somebody has committed theft in a gold shop. Now the original CCTV machine cannot be deinstalled and brought to the court. Suppose it is deinstalled only and brought to the court, then it becomes a primary evidence. Most of the time, police takes a pen drive, put it in the pen drive, and from the pen drive, they give it to the court, so it is a secondary evidence. Now, I believe I have been able to explain what is a primary electronic evidence and a secondary electronic evidence. Am I being clear? Yes, I hope so. I'm clear now.
Yes.
Now, this is the first time in the Bharatiya Sakshya Adhiniyam, section 57, they have recognized primary electronic evidence. If we see section 57 of the Bharatiya Sakshya Adhiniyam, explanation 5, it says where the electronic or digital record is produced from proper custody. Such electronic and primary record is primary evidence. But, there are 3 big however. Law we uses the expression however, but, because the real catch is now. The real case is unless it is disputed. So the court will act on the primary laptop that you produce, the mobile phone that you produce, original thing being there, only if the opposite party does not dispute the correctness of the content of that mobile phone, does not dispute the content of the laptop, etc. The moment the dispute arises, I say no, it is not genuine, as most of the accused will say, and most of the respondent in civil. Suppose it is a family dispute, forget police thing. It is a dispute between a husband and a wife. The WhatsApp chat is being shown by the wife to show that the husband is having an extramarital affair. The original phone of the husband has been taken over by the wife, and she has submitted the original phone, she is a proper custodian because she and her husband were staying in the same house. So she says that since it is the common household, I am also in custody of the mobile phone. I am submitting it to you. See, my husband is having an affair with XYZ. And she says that section 57 is there. This is a primary evidence. No certificate is required. Yes, it can be acted upon by me as a judge to grant divorce. But if the husband says, no, this is not genuine, the moment it is said it is not genuine, I cannot act on it. Why? Why should I not act upon such strong evidence? Yes, Madam Sujata is there. I will want an answer from her. I will want answers from the principals of the law colleges, whoever are present. Why we should not act on such clear, common sense view? She is the wife. She is staying with her husband. If the mobile phone of her husband, the mobile phone has been seized by her wife brought to the court, submitted to the court, and court sees all sort of things in the WhatsApp chat with one lady. And the allegation is adultery and third-party affair. Why should we not act on this? I will want one of the principal of one of the law college to answer it.
Yes, because this has been disputed by her husband. So authentication of the thing, that is the mobile or laptop, has to be checked, because that will be
Yes.
then the other party must be heard, no?
Yes, no, he is being heard. That's why he said I have objection. He's objecting.
If he is objecting, that the authentication must be checked.
Yes, yes. Any other answer? Yes, you're right. I know, Sujata. I know why. I would like to hear other views of law colleges. Because law should be all about common sense.
Yes.
Law should always be about common sense. Then why we should not act on this phone, the documentation in the court, which are appealing. We see and we are shocked. Many times we have seen in the court as judges. Why we should not act on it? Tell me. I would want some other answer. I will request some principals or vice principals or seniors to respond to it. It's very important for today's understanding. What Rosie was telling is a link to this today now. What I'm trying to convey.
It may be more.
It may be morphed or doctored by the
Exactly, Pankaj. I got one. Because the nature of electronic evidence is volatile. It is subject to tampering so easily and in so different ways that even law enforcement agencies are most of the time one step behind these hackers, behind these cyber experts. That is what Justice Nariman says in that judgment that I refer to Arjun versus Kailas, that this is subject to such volatility that law enforcement agencies and the courts will be always one step behind those persons who are doing it. So that is the region that Parliament, when they made a new law in 2023, also knew about it, and they said unless it is disputed, act on the primary evidence when it is not disputed. The moment it is disputed, go for certification. And now the case of certification comes into the picture, section 65B, subsection 4 in the original act, and now in the new Bharatiya Sakshi Adhiniyam, section 63. Now, before going to section 63, subsection 4 of the Bharatiya Sakshi Adhiniyam, I will give you one interesting story. This is again from a Supreme Court judgment. Safi Muhammad's case in 2018. Safi Muhammad versus State of Himachal Pradesh 2018. I'll give you the citation. I'm very bad in keeping things where I want to keep. 2018 2 SCC 801. It is a very interesting case. 2018 2 SCC 801. Safi Muhammad. Supreme Court judgment. 2 judges bench. Now the Supreme Court was confronted with this exact situation that I began with. That suppose I file a case against the petrol pump owner that you had filled up the full tank of the petrol and charged me 3,500 bucks. But after 5 kilometers of driving, I find that the petrol is not at all filled. I had to again refill it. And I create a document that yes, see, I had to again refill it. And so I file a consumer dispute case or a civil dispute case or a case of cheating against the petrol pump owner. If it is a case of cheating, police comes into the picture, so forget that part. Let us discuss only civil case. So I file a case against the petrol pump owner and say that, see, this is the electronic bill, and he has cheated me, so give me compensation. I demand 1 lakh rupees compensation. Now, what happened in that case is that the other party, the opposite party, naturally it is a case against him and the computer is in his custody. The certificate is to be given by the person who is in custody of the computer. He will not give the certificate. Why will he give a certificate and put it himself in difficulty? So what he did, that he did not give the certificate. And therefore, the civil dispute was dismissed by the High Court of Himachal Pradesh, saying that the electronic evidence relied upon by the consumer is not backed by the certificate under 65B4 is not admissible, dismissed. The Supreme Court was confronted with this very unique situation. Supreme Court said, "Arey, this is an opposite party. Why will the opposite party give that document? There is no question of giving the document certification that the computer was correctly there and it was in my position and this is properly generated and the machine was running properly at that point of time. They will not give this." The Supreme Court said, in such situation, the law of pragmatism, law of prudence demands that we can act even without the certificate. This was UC 2018. Okay. And this decision of Safi Muhammad, the correctness of this decision was again questioning Arjun versus Kailash, the first judgment that I referred to. Have you understood the facts in this judgment, Safi Muhammad? Mr. A filed a civil suit against Mr. B, a petrol pump dealer, saying that, see, this is a computer generated bill by the petrol pump dealer. This bill is of so and so amount, but they have cheated me, put less petrol in my tank, and therefore I may be compensated not only of the amount lost, but litigation cost, pain and suffering, etc., etc. And so they demanded 1 lakh rupees. The court below allowed the relief, granted the compensation. The petrol pump owner went to the High Court of Himachal Pradesh. The Himachal Pradesh High Court said, nothing doing, there is no certificate, you cannot act on this document, case is dismissed. The party, for a small amount, maybe his ego was hurt or something, he went to Supreme Court to get a settlement of the dispute. And Supreme Court said in such situation, the rule of certification can be waived. And because the document is in possession of the other party. Now the correctness of this decision in Safi Muhammad came up before Arjun versus Kailash, which is a 3-judge bench decision, as I said in the beginning, and Safi Muhammad was a 2-judge bench decision. Am I clear? Should we take a break of few minutes, so that we can all regroup as to what we have thought about it? Can we have some interaction with, need not be on law only, we can just talk about law colleges itself. Instead of just giving a delivery lecture, we can have a break of a few minutes and then we can restart in not a few minutes, few seconds, and then we can start in maybe 1 minute. I'm seeing Pankaj in the screen. How many other persons are there on the screen who have switched on the video? Someone screen to solve me. How many persons are there?
Yes, to come, sir. No questions are coming now.
Because naturally it is a very boring session.
No, sir. All are listening, sir. I think all are listening to it.
It was an interesting session, sir.
Yes.
We are very much in the session.
So we see, if we revert back to whatever we have said, we began with the definition of evidence and said that evidence means oral evidence and documentary evidence. Then we said that document now, after the Bharatiya Saksha Adhiniyam has come into the scene, will include electronic record and digital record. One thing I missed out here and now I repeat, what is the difference between digital record and electronic records? Now you see, electronic, generally, I mean, we think both are same, but it is actually not the same thing. As a layman, as a man not versed in science, a student of arts, I can say electronic record is a very wider term. It will include the primary evidence, the secondary evidence, the output, everything like what I have said, print out, all this. Digital evidence or digital record is the binary code created in the computer where it is prepared in a particular algorithm. That is my understanding of it. So both are now considered as document. This is the first part. The second part of my delivery of lecture today was on Arjun Pandit Rao's case. Arjun Pandit Rao was a case between MLA and the person who had lost the election. One of the crucial evidence in that case was the CCTV footage which was given, which showed that he had entered the chamber of the district magistrate, the returning officer of Nagpur, after the time was already over for filing the nomination. But this was not supported by any 65B4 certificate. His CCTV footage was not supported by any 65B certificate. Still, Bombay High Court allowed the petition, set aside the election of the MLA, and declared the losing candidate as the winning candidate. Against this, they had went to Bombay High Court, to the Supreme Court. Now, what the Supreme Court decided, we have not told about it. The third part of my lecture was on Safi Muhammad. I had tried to, before that, distinguish between primary electronic evidence and secondary electronic evidence. And during that discussion, we have understood that, see, whether it is primary electronic evidence or secondary electronic evidence, it is always very, very prone to tampering. The sanctity of the evidence is always questionable, and therefore, some sort of certification is required. Now, we can go in two ways. One, we can talk about the certification, or we can go back to the judgment of the Supreme Court. Since it is, I think, 4:30 and it's very difficult to keep the mind of the audience alive now, I will go to the facts of the case only. I will first tell you the decision of the Supreme Court, which is very interesting. The Supreme Court has dismissed the appeal of the winning candidate. Not only the Supreme Court has dismissed the appeal, Supreme Court has also imposed a cost of 1 lakh on the appellant. That why have you filed this faltu case before us? He was a sitting MLA. His election was dismissed. He filed an appeal. His case was also very good. That see, the video recording that has been submitted by the respondent is without any certification. Still, Supreme Court dismissed his case and said nothing doing. This is a faltu appeal, 1 lakh cost. So he was removed from the post of the MLA. The other person who had lost, he became the MLA, and he had also to pay cost. And all this happened without certification. Now I'll tell you the law. Supreme Court in Arjun Pandit Rao versus Kailash has said that certification is a must. Without certificate, we cannot act on secondary evidence. How do you reconcile this? On one hand, Supreme Court is saying this CCTV footage we will act, even though it is without certificate, and let down the general law that no, without certificate, courts cannot act. What happened? Why this was so? How many of us have read this judgment, Arjun Pandit Rao versus Kailash Kotkar? Judgments are generally boring because it runs into hundreds of pages. Who will read? People like us who have no work, they read. So, what actually happened was in this case was the Supreme Court distinguished primary electronic evidence from secondary electronic evidence, as we have discussed, then said that both primary and secondary evidence are susceptible to tampering or adulteration and not a correct version being presented to the court, and then said that no, see, certification is necessary. Certification in the format desired by 65(4) is necessary before bringing it on record. Still, Supreme Court in this case acted on the CCTV footage for one primary reason. When this case came up before the Bombay High Court, and Bombay High Court issued notice to the returning officer to submit the CCTV footage, on one pretext or the other, the footage was not given. And the Supreme Court has noted, the majority decision has noted, no doubt about it, because it was with respect to the ruling party candidate who had won, to the returning officer being an IS officer, was not giving the certification for one pretext or the other. Therefore, the Supreme Court applied a theory in law, which we are all empowered to apply, which says that a judge is not expected to ask, when the situation becomes impossible, the Latin verb, when the situation becomes impossible, then the judge can act in his discretion and permit an evidence which otherwise would not be admissible. The Supreme Court said in this case, because notice was issued to the returning officer not only once but twice, and the returning officer on one pretext or the other did not submit the 65(4) certificate, Therefore, even without the certificate, the Bombay High Court was correct in declaring the election null and void. Thereafter, Supreme Court said, in these facts, not only we are dismissing the appeal, but we are imposing a cost on the ruling party candidate. And so it imposed a cost of rupees 1 lakh. So now we have understood the certification is a must. So when we are talking to law students, we will have to tell them that when you talk about CDR footage, what is it called? Call detailed record in the criminal cases, or in civil cases, when some party will come up with a WhatsApp chat or obscene photographs pasted on Facebook, the first question that need to be asked to the witness is, have you submitted a certificate under 65B4 or 63(4) of the Bharatiya Saksha Adhiniyam? The witness will say no. The police officer will, in most of the time, say no in regular cases, not a high-profile case, like a case of theft. Then no other questions are required. The evidence, electronic evidence, becomes inadmissible in record. The matter ends then and there. So as a law teacher, when we are teaching law graduates who will either be defending the prosecution or fighting against the prosecution, they have to be taught one basic thing, that whenever electronic evidence is presented by the IO during investigation, the prosecutor must ask that, have you obtained the 63(4) certificate in proper format or not? If it has not been obtained, the case diary should be returned by the prosecutor to the investigating officer to present this certificate. Because when most of the time, my experience as a judge in 22 years is that these are genuine documents that the investigating officer is presenting, call detailed records or WhatsApp chat, etc. But they are not backing it up with the certification which is mandatory. And therefore, the first role is of the prosecutor at that stage to tell the IO, I am not going to accept your case diary with the charge sheet because this is lacking. And to the defense lawyers, this should be the first plea in the cross-examination, whether the electronic evidence is supported by certification or not certification. I believe the audience which is available here will understand that this is very important. The certification is very important because the document is prone to tampering, as she said, morphing, whatever word you say. Morphing is an old word, in the new world we say Photoshop, etc., etc. So that is why certification is required. Now let us assume that certification is given. Let us assume it is a murder case, and police has been very careful. They have given the certification as required. They have shown the tower location in the CDR. They have given an analysis also of the CDR and tower location to show that the place the place where the murder took place, the accused was at or near that place, and after the murder he has switched off his phone and run away. So there is a conduct also. Police is showing that, see, if had he not committed the crime, he would not switch off the phone. So this is another conduct against him. Now, how as a defense lawyer, what will you ask the police officer? The multiple gates are there. Admissibility, the moment certification is given, it becomes admissible in evidence. Relevancy, most of the time, dark case thake, so relevant evidence is the extramarital affair. If he has pleaded extramarital affair, the wife will give evidence of WhatsApp chat. If it is a case of murder, the police will try to show that the accused was at or near the crime scene at the time of the incident. So evidence most of the time is relevant. The second check post apna easily pass koribo. Tata sentry to lose thake aro jau jak bairo boli koi dibo. First check post digdari ase, certification has to be proper, correct, halke sabo, properly checked. Certification is okay, you cross the first check. Second check gate, it is a very light check gate, you can go through it. The third check gate now comes in the picture. You are a good lawyer. You know, if this evidence is brought on record, I am gone. I will be sent to jail for 14 years. So third check gate is section 39, subsection 2 of the Bharatiya Saksha Adhiniyam, earlier section 45A of the Evidence Act. Now what does it say? That began by saying the value of that evidence, whether it is correct, not correct, genuine, not genuine. So if you dispute the value of the evidence, then the court is bound to direct the police, or in a civil case, the party who has led the electronic evidence, to examine one witness who is called examiner of electronic evidence. Na, Roji? Examiner of electronic evidence. Section. So there is a list given by the government of India who are examiner of electronic records and digital records. So to determine the correctness of the document that is placed by the police, placed by a party, you have an option. You can say, I dispute it. Please call the examiner of electronic records. This is a third check post. So he will come and you will cross-examine him. You will ask that person some questions and he will answer to those questions. That is cross-examination in simple language. It is a question-answer session as I tell in my court. So the lawyer, or if he is armed with some legal technical experts, he will ask those questions to the examiner of electronic records. The examiner will give the answers. Based on that, the court, person like me, will determine how much weightage we'll give to that evidence, electronic evidence. So these are the three check gates in this case. If you cross the third check gate, most of the time, genuineness, once the certification is there, is correct. But there can be a person who can temper it in a way that common people or even judges and police may not be able to understand. So in such cases, we need the examiner to determine the correctness of the electronic record before us. The third check gate. If the three check gates are, you can cross through it, then you go to Shillong, you cross Assam. You have reached your destination. That is all. Thank you, everybody. I open it to some questions, but at 4:45, I don't think anybody will have questions. There are something in the slides. I have not presented the slide of that. I prepared it. I normally do not present slides. But today I thought this is the third one. Now I'm showing secondary evidence. And this one is the 63 certification. 60, and this is the 39.2 and this is the form. So I prepared it today. These are the slides which I prepared. And I hope I have been able to add some sense to electronic evidence. It's a very simple thing, put in a very difficult way by me. I hope you will excuse me for being so difficult and hard. Judges are expected to be difficult and hard. Otherwise, nobody gives respect to us. Thank you very much. Thank you, everybody.
Thank you, sir.
Thank you so much, sir. Thank you, ma'am.
Most screen to on for you, please.
So I now request Vijeta Chetri ma'am to offer the vote of thanks for this session.
Namaskar, sir and madam. Good evening, sir and madam.
Good evening.
So now we come to the conclusion of these two sessions. Today we are very much privileged and honored that the eminent person of Assam is amongst us, and I, on behalf of the organizing institution, would like to express my heartiest thankful to Mr. Rosen Lal sir. Sir has explained and analyzed all the issues very minutely, from the definition of document to case law. The name of the case law is Arun Pandit versus Kailas, related to the electronic and digital records. Sir has also explained case law related to the primary electronic evidence and secondary electronic evidence, how it is examined in this case. And I also would like to express my heartiest thankful to Dr. Rosie Kalita madam for sharing your knowledge and 23 years of experience in the field of crime and criminals, as well as the problem of AI related cybercrime in India. Both these sessions were very highly and knowledge gaining, enriching session with all the examples and slides, particularly the sensational case of Jubin Garg. Once again, thank you, sir and madam, for giving your valuable time despite your hectic schedule. Hope we will find you in our future program very soon. I would also like to express my heartiest thankful to the organizing committee and all the participants for their active involvement and all the principals of both the colleges. And thank you very much to our organizing committee.
Madam Chetri, I want to add one line which I have missed out. The
Okay, sir.
question that was raised in the Safi Mohammad's case was, what will happen if the opposite party does not give these documents? Most of the time it will happen, the opposite party will not give the certification. The Supreme Court answered in Arjun Pandit Rao, said that in such cases, courts should direct the party.
Okay, sir.
Court has the power, both civil cases and criminal cases, to direct the opposite party to submit such document. And it went on to say that court should also cross-check whether the opposite party has tampered with the document. The answer has been given in Arjun Pandit Rao, but as I was speaking extempore, I missed it out. But that is the answer given. Thank you.
Pardon me, sir. Thank you. Thank you. Once again, thank you to all of you. Sir.
Thank you so much. Thank you.
Thank you, sir and ma'am.
Thank you, madam.
रसना है कल लगेगा लगेगा